A very good morning to everyone. This side CA Aishwarya Jaju, and I warmly welcome CA Jatin Harjai sir, the speaker for the day, CA Moshmi Shah ma'am, Managing Committee member and Chairman of Pune Vikasa, and to all the enthusiastic participants. It's really pleasant to see all of you on the Sunday morning. Before starting the day, I would like to make an announcement of the 36th Regional Conference of WIRC, which will be held at Pune. This is just a glimpse of the event. Ma'am, can you please share the video? Reshma, ma'am?
Yes, 2 minutes.
Good morning, sir.
Share in meantime.
Sorry?
I will share it in meantime. You may continue.
Okay. So, welcome Rajesh, sir. He's the Vice Chairman of Pune ICI. Before starting of the day, I would like to make an announcement. So that will be continued a little later. We are on the day 3 of our GST litigation series, and I'm pretty sure all of the participants had a wonderful value addition throughout the last 2 days. Today, we will be throwing light on how can we effectively reply to our show cause notices and appeals issued by the authorities. I request CA Moshmi Shah ma'am to please welcome our speaker.
Thank you, Aishwarya. And a very good morning to all the participants in this 3 days virtual GST refresher course organized by Pune ICI jointly with Pune Vikasa. And I'm very happy to have with us CA Jatin Harjai sir, who will be talking today on effective reply to show cause notice, appeal before appellate authorities. In fact, when CA Rajesh Agarwal sir, Vice Chairman of Pune branch, thought of organizing this wonderful series, he couldn't have found a better name than Jatin sir. And all thanks to you, sir, for being here. Before I hand over it to you, a small announcement to all the audience. It is for the first time that we have the regional conference happening outside Mumbai. Every time till now, the regional conference happened only in Mumbai, and this is the first time wherein Pune ICI is organizing it at Pune. So it is going to be a wonderful, wonderful series. I request all the participants to please register for this 2 days conference, which is happening here. Opportunity for all Puneites to attend it actually. Otherwise, we would have had to go to Mumbai for 2 days. This time it is beneficial for us, opportunity for us. So please do make it on 3rd and 4th of June this year. Over to you, Jatin sir.
First of all, thank you very much, Pune branch and all the participants. It's actually wonderful to speak to so many people at this Sunday early morning. Actually, difficult to say that so many people wake up this much early. Anyways, so this is GST, and GST is all about litigation. We all know about it. So that's why I must compliment Pune branch that they have arranged a series which is fully dedicated on litigation aspects. See, we all have seen GST for more than 4.5 years or maybe near to 5 years now. I'm sure whosoever is actively practicing in GST or are very much regular in that, you will agree with me that it's very difficult or hard to find any provision of the GST law which doesn't have multiple interpretation or which doesn't have any issue. So each and every provision has some issue or maybe multiple interpretations kind of things. And I don't want to criticize the lawmakers as of now at this point for this aspect at least, because law is at nascent stage. Whenever there is a new law, it's bound to happen. At least in India, it is bound to happen, because people are like us, has a specialized brains. We try to read the same line in a different manner. We can have examples while we are going through with this particular presentation. Not presentation, I would say, I'm just extempore speaking. I don't have any specified agenda in my mind that I'll go by this or that. If any participant require me to address a particular aspect, please do write on the maybe communicated to Aishwarya ji, or maybe if there is any chat box, you can, yes, chat box is there. So you can write there, then I'll try to address that aspect. Let me start with because today's topic is replies to show cause notice and appeals, correct? So these two aspects I'll cover in next 2 hours time. Before I start, let me discuss some very fundamental aspects which we all know, but at times we forget. See, Article 265 of Constitution of India, which is basically a mother provisions for all the, I would say, taxation administration. It says, no tax shall be levied or collected. Please mind, this word is very important, collected. No tax shall be levied or collected except by authority of law. Until unless there is a legal provision, no tax can be levied and no tax can be collected. This line is written in Article 265 in a negative manner. It will convert it in affirmative. Then this or will become and we can read it like that. The tax has to be levied and collected by authority of law. It is not only levy but collection as well. You will find at so many point of time under even the other taxation laws as well, there are irregularity at the part of the department that they have not proceeded with the collection procedure prescribed in the law. Not only levy, collection procedure, collection provisions or procedure. And in GST, I can say, I'm yet to see a single notice or a single order in which we cannot, in which we can find any error. Meaning thereby, in each and every order or in each and every notice, which at least I have seen till now in GST era, in last 4 or 5 years, each and everyone was having some kind of deficiency, one or another. So when we are into litigation, please mind that these two are altogether different categories. One is consultancy, another is litigation. So approach has to be altogether different. Please mind it. As a friend, I am telling you my experience. Whenever there is a person who comes to me to consult some provision for his future transactions, normally I give advice to him so that there will be least litigation. Or if there is a litigation, it is a calculated litigation. That means if we are not taking that particular route, then there will be a huge cost. So that is what consultancy. The way we read the law, many a time in light of how government understands it, how the government officers understand it. But when we step into the shoe of a counsel as a litigation expert, please mind how the government is understanding, how the officers of the government is understanding the law is nothing to do with it. Circular, nothing to do with it. I can say about one line about circular. If it is beneficial to you, please use it, otherwise throw it. It is not allowed. Absolutely not allowed. No circular, no order, no press release, no AAR, except in the case of the person who sought it. It is absolutely not the law. You can take my practical experience whenever you are arguing in any of the court. Many a time I have seen this thing. The government counsel more relies on the circular. And most of the judges you see, they'll reply to the circular in one line. Is it beneficial to the assessee? If answer is yes, then definitely he would not be showing that circular. If answer is no, throw it. We want to understand the law, not the circular. When required, I'll come, if required, or maybe some queries are there on circular, I'll come on that again in a respective situations. But coming back to Article 265. So levy, whenever we are talking about levy, it broadly covers under the GST like what is the taxable events, who is the person liable to pay tax, what is the rate, what are the input tax provision, what is the valuation mechanism. Each and every aspect is some way or another is related to levy. So this is what we deal in extensively. Now, if I talk about collection, collection is what? All kinds of inquiries like search, inspection, audit, scrutiny, etc., etc. Then adjudication, then recovery or filing of the appeal. These all are these collection mechanisms. So department cannot do any collection exercise otherwise than by way of a manner which is provided in the law. There are so many classic judgments from the Honorable Supreme Court which talks about it. That if law provides a particular method or manner in which a collection provision or other provision has to be carried forward, has to be done, and then it has to be done in that manner only, no other manner. One classic judgment is Municipal Council versus Kamal Kumar. Income tax, if we talk about Seth Brothers, procedure what is prescribed has to be followed. And one of the favorite, not from the taxation law, the other law. One of my favorite is Shri Mandir Sita Ramji versus Lieutenant Governor of Delhi. In this particular judgment, it is a old judgment of 1975. In this, even the Supreme Court told that even the courts are not open. It is not open for the courts even to follow the procedure which is otherwise done by way of as the provided by the law. Even courts cannot go beyond that particular aspect. So why I am going to give stress on it? Please try to understand the importance of this thing with the numbers. If you'll recollect, CAG report on indirect taxes was presented in the Parliament in 2019. Please recollect. Please recollect the numbers of the demand versus recovery. How much demand has been made by the department and how much recovery has been paid by the department? What kind of difference was there? Can anyone just guess? Can anyone just guess on that? I'm waiting for you on the chat box if you can write there. Okay, in Q&A there is a question. I'll take it up at last. In chat box, I think we can post our interact. Let's have an interactive session. You can post on chat box. Okay, one answer is there, 5%. If let me repeat that my question. What is your guesswork about how much departments recovers out of how much demand is being created? Okay, I have 3-4 answers. 3 answers are there. 1%, maybe 50%. Okay, so guesswork is varied from 1% to 50%. Please mind, by the time it got deteriorated in the earlier tax regime, if we talk about undisputed amount. If we talk about undisputed amount, that it was roughly 9% in the 16-17, which got reduced to 6 to 7% in the 17-18. And if we talk about gross arrears, it was approximately 2% and reduced in the next year, 17-18 as well. So you can see what kind of gap is there. And let me tell you, one of the important factor, I'm not saying sole factor, one of the important factor is lack of the department, lack of following the procedure on the part of the department. This is one of the, someone says voice is low. So I hope it is audible. So anyway, so one of the important factor is procedure has to be followed. Now let me again come back to one aspect which I'm going totally practical in this session, how I deal with the cases which comes to me. Many a time you will see that a case is very strong on merits. Let's say in your opinion, input tax credit is eligible. Department say, no, input tax credit is not eligible. But you think the legal provisions are fine, then you will definitely suggest your client to go ahead, file the appeal, etc., etc. And you must have, you must be saying that, okay, we'll get a relief on the first appellate forum, if not on the second appellate forum. But what happens if you think the case made by the department is strong on merits? What happens then? Please mind, whenever there is a battle can be won by two ways. Number one, with your strength. Number two, with the weakness of opponent. And that is very much true in tax litigations. Maybe your case is not that much sound on merits, but please check it on technical aspects. Whether technically any lapses are there on the part of department. If department has done any technical lapses, I'll discuss maybe 4, 5, 6, 8 different type of technical lapses which department does commonly. So in that case, it will go. Let me give you a live example which we recently happened. Now what happened under the service tax law? The same will apply in the GST as well. Recently we received a show cause notice from the service tax DGGSTI. Now DGGSTI, earlier it used to be different name. In 2019, we received a show cause notice for demand of rupees 22 crore plus interest plus penalty, totaling approximately 49 crore demand for a company who was dealing in back office operations. In our view, the services were export. In the view of the department, services were not exported. It is actually a question of law, which is to be decided in due course of time. Maybe a 50-50 course, depending upon subject matter of the case. What I observed at that particular show cause notice, that they have not given a pre-consultation. They have not given the pre-consultation. What we did is, despite contesting the case on the or replying to the show cause notice, we directly filed a writ petition before the Honorable Delhi High Court. And last year only, in 2021, the case name is Back Office IT Solutions. The whole of the case got quashed. Only with that reason that pre-consultation was not given, which was a mandatory requirement. So if the pre-show cause consultation was not given, so Delhi High Court only and only on this ground has quashed the whole of the demand, whole of the show cause notice. Now you see, even we have not responded to the show cause. Adjudication doesn't happen, has not happened in that case. No appeal, nothing. So at times we have to decide in the interest of the client. Because see what happened if we were supposed to file a writ petition, responded to the show cause notice, department, you know what department do? They just confirm what the show cause notice is. And in that case, if we would have been filed an appeal, a huge amount was supposed to be deposited for the pre-deposit as well. So many a time this may be the call that if we don't have a funds and have a strong case, may directly go in a writ petition. But this is a call which is to be taken on a case-to-case basis. Coming back to the aspect which I was dealing. Let's see, under the GST law, we have a threefold mechanism. First, there has to be an inquiry. Then there is adjudication. And thereafter, recovery can be there. Either recovery or the appellate route goes. Whenever I say about the inquiry, what does the inquiry is? See, whether department is doing a scrutiny, whether department is doing an audit by the departmental officers or by a specialized agency like Chartered Accountant, CMA, or they are conducting an inspection or they are conducting a search and seizure. All these are nothing but a fact-finding exercise, fact-gathering exercise, or you can say it is an inquiry process. Issuing the summons, all these are inquiry proceedings. Please mind, no demand has been created till the time adjudication is being made. These all are inquiry proceedings. That means no one is supposed to pay a single rupee till the adjudication has been made. It is only and only an inquiry. Department is gathering some information. Department will make up some view on that, and then will make a case against you, giving an opportunity to you. So precisely all these has to be in a single basket. I'm not entering into any of these particular areas: scrutiny, audit, accessor, seizure, inspection. As of now, I'm not entering into that. I'm sure it must have been catered otherwise, or I'm not sure whether it is a part of this course or not. But we need to understand this is the inquiry proceedings. Then once the inquiry is complete, let's say there was a scrutiny. So scrutiny under the GST law is not like income tax law, that if once the case is under scrutiny, then there has to be order has to be passed. No. Scrutiny has to be done by the department on their own. If they find some discrepancy, they are supposed to give a notice which comes in a ASMT 10 commonly. Scrutiny happens even before that, before the ASMT 10 comes. So scrutiny is done on their own with the available information with them. If they found any discrepancy, they can ask. So the mitigating factor of the documents inform ASMT 10. Even if they are not satisfied, they can proceed for the adjudication. No order is supposed to be passed in pursuance of the scrutiny itself. So once the inquiry is over, that means whether it is a scrutiny, inspection, search, seizure, audit, whatever. Now the department has a material to frame a view that there is some tax has not been paid, or short paid, or input tax credit has been wrongly availed or utilized, or some refund has been erroneously taken by the department, by the assessee. In that case, the department can proceed, or rather department will proceed for the adjudication proceedings, not recovery. Now there is a question, can adjudication be done directly? Answer is no. There has to be some inquiry before that. Otherwise, how one will make an opinion? Otherwise, how an officer will make an opinion or frame a charge? Show cause notice is nothing but a charge sheet. Please mind it. Just like you understand that let's say there is a police case is being made, then police first inquire it, then prepare a charge sheet and file before the court. So this show cause notice is nothing but that charge sheet which is being made by the departmental officers. And for that, there has to be an inquiry. Without inquiry, there cannot be adjudication. Many times you will see, more specifically in case of state officers, that without inquiry, they make directly a show cause notice. Please mind, absolutely wrong in my humble opinion. No homework. Homework has to be there. Without their homework, it cannot be. Otherwise, it will be only a third-party information or some hearsay like this. As you are well aware, when we are talking about making a case or adjudication, a show cause notice is a must. Show cause notice has to be there. And we have two provisions, section 73 and 74. If after conduct of the inquiry, department is of the opinion that whatever tax has not been paid, short paid, input tax rate has been wrongly availed, utilized, or erroneous refund is due to the reason of a fraud or willful misstatement or suppression of the fact to evade the tax. In that case, it will be 74. Rest all the cases, we can say bona fide cases. In that case, 73 will apply. More or less provisions are same. We'll just touch upon what are the differences. Maybe statutory provisions not more than 15 to 20 minutes. Then we will come up directly on the issues which one should be well aware about it. How it is to be seen. So once this show cause notice is there, which comes in DRC 01, thereafter you are supposed to respond that you will be having an opportunity of personal hearing. Thereafter, an adjudication order has to be passed. There comes a very important aspect. Once the order is passed, then only someone can say that the now amount is payable. Let us say adjudication order is passed, which is against your opinion. In that case, now the demand is created on the assessee. This demand either has to be paid within 3 months time period, or law provides you an opportunity that you can file an appeal before the first appellate authority within 3 months time frame. That means for both time frame is 3 months. That means you have to decide within 3 months you have to pay. You want to admit that liability, or you want to litigate it. That means you are not agreeing with that liability, you are not agreeing with that adjudication, and you want to file an appeal. If you are going to file an appeal, some certain prerequisites are there, which we will discuss at a later point of time. So this is what a whole ecosystem, inquiry, adjudication, then either recovery or appellate mechanism. So this is what a whole ecosystem which we can divide in these three parts: inquiry, then adjudication. After adjudication, there are two ways. Number one, either recovery, or number two, appellate mechanism. The moment you will file the appeal, the rest of the demand will get staged after pre-deposition of the same. But now what happened? Practically, you must have seen that in the department, for all practical purposes, the moment there is a inquiry starts, departmental officer starts making pressure that you deposit the amount. Let it be scrutiny, let it be audit, let it be any other proceedings, summon proceedings, and in case of inspection and search, they come with the targets that this much amount has to be deposited. So as I already said, these all things, audit, scrutiny, inspection, summon, search, all these are the inquiry parts, and liability to make payments come when after 3 months of the adjudication. That means the moment inquiry is there, show cause notice, order is being passed, then you have a 3 months time frame to deposit the amount. If you are not depositing within 3 months, then the department can recover it through the recovery mechanism. I would like to bring your attention to section 69. If Aishwarya ji can help me to share the screen, section 79. I think I'm just bringing couple of chain of section, which is very important whenever you have a case of recovery in front of you. Section 79, section 79, read with section 73 or 74. The moment the legal, you don't need any case laws. The law is crystal clear. And you just please mention 79. Control F 79 up dal dijiye. 79 dot. Next, please. Okay, by the time I did this one. So please read it. Section 79 is about recovery, when the recovery can be there. Where any amount payable by a person to the government. So first of all, there has to be amount payable. The day when search is being made, whether there is any amount payable, answer is no. It's a fact gathering exercise. It's an inquiry. No order has been passed. So how come we can say that there is an amount payable? Now let's link it with the other provisions. Please go bit up in section 78. It specifically says any amount payable. Please read this. Any amount payable. Again, this is talking about the amount payable. That means after passing of the order, and this the law will itself say that after passing of the order, amount is payable. I'll show you. Just a moment. Hold on. Amount payable by a taxable person in persons of order passed under this act shall be paid by such person within a period of 3 months. Within a period of 3 months from the date of the service of such order, failing which recovery proceeding shall be initiated. The recovery proceeding shall be initiated only and only after when a person failed to pay the amount within 3 months from the date of the service. And this is also very interesting. I'll touch upon this aspect. What is date of service under the GST law? When any email is being received, or maybe a demand notice is served on common portal. I'll touch upon that a bit later. So many cases are there on it. So 3 months you have. Before the 3 months, no one can recover. No one can start recovery proceeding. You have seen section 78 and 79. Madam, can you go bit up and open section 74 or 73 subsection 9? Subsection 9 of either section. 73 and 74 subsection 1 says that proper officer is supposed to give a show cause notice. Then you will file, then assessee will file the response. And this is what the subsection 9 in front of us. Subsection 9 says the proper officer, after considering the representation, if any, made by person chargeable with tax, determine the amount of tax. Now please recollect here and touch it, correlate it with the definition of the assessment, which is provided in the definition clause, if I'm not wrong, 2.6, which says what is an assessment? Determination of the tax amount. So this is what a process of assessment is happening. Determine the amount of interest and penalty equivalent to 10% of the tax amount, whichever is higher, due from such person, and issue an order. So this is what assessment is happening. Amount is being determined. And now this amount will be due from such person, and for this the order shall be issued. So the day when order is being issued, only and only when some amount is becomes due to pay to the government, and no recovery provision can be applied before this kind of determination, meaning thereby when the audit is being under process, scrutiny, inspection, search, no one has right, departmental officer doesn't have any locus to say that you deposit the amount forcefully, or in fact there cannot be any advisory on it that you deposit this kind of amount. Couple of judgment on this aspect are, we know Bhumi Associates, the persons who are extensively dealing in GST, they are well aware about it, but just for bringing everyone on same portal, on same platform. Bhumi Associates from the Gujarat High Court, interim order dated 16 February 2021. That's very important. Whereby the Honorable Gujarat High Court has specifically talked about 4 aspects. Number 1,
if there is an inspection, if there is any proceeding under section 67, that means inspection or seizure. In that case, no recovery has to be made. No recovery by any mode has to be there. Second point, that even if the assessee is coming to pay voluntarily, in that case also the voluntary payment should also not be allowed, and the officer should say that please pay the amount once we leave the premises, yani after us, once we leave the premises. Then they talk about if assessee feels that there is some malpractices or some coercion or the assessee was treated badly, then a complaint or grievance should be filed, and for this filing the department should enable the mechanism for it, kind of grievance portal. And if such kind of complaints are there and on inquiry it is found by the senior authorities, strict disciplinary action should be taken. So Gujarat High Court came heavily on it that you cannot recover any amount during proceedings. Why this has been happened? Because High Court said, okay, you cannot recover anything during inquiry. Once you may be having a different opinion, assessee may be having a different version of the legal provisions, let's adjudicate the matter, go into appeal. Why you are recovering it first? On the similar analogy, there are plethora of judgments are there. One famous is from Madras High Court, Nandi Dal Mills, April 2021. Then deemed distributors, it is from Telangana High Court, August 2021, in which a very famous quote was there from the court that you cannot put the horse before the cart before the horse. Sorry. So recovering first will be just like putting up a cart before the horse. Similarly, recently, Bundle Technologies Private Limited, Swiggy case, which was decided by the Honorable Karnataka High Court single bench in September 2021, in March 2022, the same has been confirmed by the DB of the same court. So no recovery. These all are the recent judgments which are there under the GST law. Now coming back after this recovery, after discussing that no recovery can be there until unless complete adjudication is there. Let's come back to the show cause notice. Very commonly I have seen we are receiving the show cause. The moment you receive a show cause notice, first work which should be done by any person. First one, please carefully analyze whole of the contents of the show cause notice, whole of the content. Many a time you will find the moment you are reading the show cause notice carefully, you will find so many issues. Let's try to identify what kind of common issues are there in show cause notice nowadays in GST law. Normally what happens, inquiry is under ASMD 10 is happening, or maybe some search or inspection has happened, and department has issued, after maybe a couple of inquiries, department has issued the show cause notice. Let's take a pause here. Refer to Rule 142, Sub Rule 1A, which is similar to the provisions of pre-consultation, which was there under the service tax regime. Rather, I would say much stricter. In the service tax regime, the requirement of pre-consultation was where the demand is, tax demand is more than 50 lakh rupees, whereby no such rider is there under the GST law. Madam may open Rule 142 as per their comfort. CGST rule 142. Anyway, second aspect. I think, madam, this is part B of the form which you have downloaded. Please download the part A. CGST rules part A. You may download it from the system. And then, no, this is forms which you are showing. You just please download CGST rules 2017 part A. Then there will be a rule 152. Let's go ahead by that time. Jurisdiction. Normally, the moment the word jurisdiction comes into our mind, we thought, okay, jurisdiction means a particular area where a particular officer is having jurisdiction to exercise to execute their functions. But please mind, in GST law, the jurisdiction has been multifold. In the earlier tax regime, we used to check jurisdiction from 3 points of view, from 3 angles. Number 1, territorial jurisdiction. Number 2, functional jurisdiction. Number 3, subject matter jurisdiction. Whether all three are there or not. Now in the GST law, in my humble opinion, a 4th kind of jurisdiction, which is a divisional jurisdiction, also has been added. So the moment you receive a notice or summon or an order, please check on all 4 counts whether you have received it or not, whether you have all the 4 type of jurisdictions are correctly described or not. Let me give you an example. For all 4 jurisdictions, I'll give you 4 examples, because there are different cases, different things are applied. Let us say you are sitting in Pune, and an officer of the state taxes, SGST or maybe CGST, hardly makes any difference, from the Bombay sends a summon to you or to your client. Whenever I'm saying to you, that means your client. We are talking about a businessman only. Can you tell me what is the distance between Bombay and Pune? Can anybody tell me the distance between Bombay and Pune? Is it more than 200 miles? Is it more than 200 miles? 150 kilometers. Then we have to change the this particular example. You are sitting in Pune and you are receiving a notice from an officer whose office is situated, whose regular seat is situated more than 200 miles from your place. Now let us say your client receives or from Rajasthan, let us say from Rajasthan, your client receives a summon. Now Rajasthan is certainly more than 200 miles from the Pune. Question comes, can this summon be served by the officer of Rajasthan, be it state taxes, be it central taxes, to the person who is normally residing in Pune? My answer to this is absolutely no. My answer to this particular thing is absolutely no. Why I am saying so? He doesn't have the jurisdiction. My answer would have been the same even if it is within Maharashtra, correct now? So accordingly, you can take up the example or the spirit of the example. Reason is, please refer section 70. Section 70 subsections 1 says the proper officer may issue the summon to so and so this. And all the provisions of the CPC are applicable to these proceedings. If you can open the Act, CGST Act, which is in the other, and open section 70. Yes, this one. Section 70. Just mark a 70, then press a dot. Not 17, 70, 70. Thank you. Yes. So it says the proper officer under this act shall have power to summon any person. Prima facie appears that any person. किसी को भी बुला सकते हैं, no. Whose attendance he considered necessary either to give evidence or to produce a document or any other thing in inquiry in same manner as provided in the case of civil courts under the provisions of CPC. Now, CPC provides, Code of Civil Procedure, Section 27 that with Section 28 provides, or enabling provisions are there, how the summon is to be served. And there are Order 5 of the CPC, just like a kind of, we are having a schedules in our act. Order 5 describes that how the summon can be served. If it is within original jurisdiction, yes, it can be served by anyone, any court. But beyond that territorial jurisdiction, there is a rider of 200 miles. If the two places are connected with the public transport, otherwise it is less, even 50 miles, if I'm not wrong. So now every city is connected by public transport. So we are taking it as 200 miles. So if it is more than 200 miles, that court directly cannot serve the notice, cannot serve the summon. And the CPC will apply to the summon issued under the GST law as well. So whatever be the things are, whatever be the merits of the case are, in my humble opinion, issue of the summon directly by the officer situated in Rajasthan, be it the state tax officer, be it the central tax officer, is absolutely out of jurisdiction. Let me give you the example of another type of jurisdiction which one has to see the moment you receive the notice. The moment you receive the summon or notice, you must remember. Now there is a question, if I have a depot or branch in Rajasthan, fine. See, please mind, summon is to be issued to a person, because summon is normally to take a statement. The issue is whether a person is supposed to travel to that officer or not. If there is a summon which asks for some information, I normally advise you send the information, chapter ends. But if the problems are when the officers wants the assessee or the taxpayer to travel to their offices, whereby unnecessary harassments are there. So in that case, what's going to happen? The summon has to be issued in the name of the person, not in the name of the company. So even if you are having a branch in Rajasthan, but the summon is being served by the state officer to the person sitting in Pune, same provisions apply, and summon should not be there. Yes, I'm responding this question only. That even if you are having a branch in that state, I'm giving you an example within the same state, hardly matters. If you are sitting in let's say you are in Maharashtra, you are registering in Maharashtra at Pune, and an officer who is 200 miles away from your office within the same state, then also he cannot serve directly a summon to you. Now there is a next question from Mr. Nikhil Kiran. Whether same is applicable to the summons received from DGGI, please take a pause. The answer is no here. This particular point is not applicable on DGGI. Why? If you heard me completely what I explained about where a summon can be served as per provisions of the CPC, Section 27, read with Section 28, read with Order 5. It says where the officers are having original jurisdiction, they can send to them. Officer, rather it talks about code. CPC talks about code. As per the original jurisdiction of the code, anywhere it can be sent. Now what happened, particularly in case of DGGI, the notification, the GST notifications assigns the territory for whole India. That's the problem with the DGGI. So be careful when the summon is received from the DGI, then you cannot take this plea. But if it is from being received from the another state's officer of the state tax, central taxes, within the state, from the central tax, state tax, regular wings, then it cannot be. Also, please mind, I'm making one more caveat to it. Please mind, at some places, the anti-evasion wings of the state officers are also have given the state-wise jurisdiction. So in that case, within a state also, you cannot take that plea. So you'll have to be crystal clear on this aspect. I'm just touching upon this aspect. I was not meant to enter into that great detail. Otherwise, we'll leave other aspects. So this is one aspect which one should be well aware that I need to check territorial jurisdiction, whether the person who has issued to me the particular notice, whether he is having a territorial jurisdiction on me or not. Number two, functional jurisdiction. Now the functional jurisdiction is what? Please recollect early 2020, when there was a flood of notices on gross or net interest basis. The department has given it so many notices all over India that you pay this amount, otherwise we will recover it. Interest on gross basis. Now what happened? Please go and check your records whether who has signed that particular notice. I have received hundreds of notices at that particular time and got a common thread that except 2 cases which were in front of me, each and every notice was signed by the superintendent. And each and every notice used to say that if you are not going to pay this interest, which is calculated on gross basis, then we will recover it under section 79. Section 79, which I produced before you earlier. One facet I have discussed, I am discussing another facet of 79. Question here is whether the officer, that is superintendent, was empowered or assigned the function of recovery. Can recovery be made by the superintendent? My answer is no. Please check for this purposes circular number 3/3/2017, which assigns function to the officers. Superintendent was never assigned to issue a notice for recovery. So that is a functional jurisdiction. Third aspect of the jurisdiction can be a subject matter. For example, you have received a show cause notice under section 74. Now, what is the subject matter of 74? 74 can be issued when there is non-payment of tax or short payment of tax or wrong availment of input tax credit or wrong utilization of input tax credit, and lastly, erroneous refund. With the fraudulent intention, with fraud or willful misstatement of fact or suppression of the fact. Now, what happened? You have received the show cause notice whereby department has alleged the classification. Department has alleged the classification that, okay, you are charging a particular item, you are charging tax rate of 18%, whereby in the opinion of the department, the tax rate should be 28%. So this is what a correct, whether this is correct to issue a notice for the classification purposes in section 74. This is what a subject matter jurisdiction. In my humble opinion, answer is no. Fourth. Now, which is a new facet in the GST. Assessees are divided into state and central offices, between state jurisdiction and central jurisdiction. Is it justified by the state officer to issue the show cause notice to the assessee whose division has been assigned to central taxpayer or vice versa? In my humble opinion, absolutely no. If required, I'll dwell this aspect in detail. So this cannot be done. Next. I can say one aspect is whenever you find any of these kind of discrepancy, precisely which we have discussed. Okay, madam, can you once again come up with section rule 142(1)(a), which you just downloaded, rule 142. So I've discussed 4 type of jurisdictional thing. One is pre-show cause notice. Please rule 142. Rule. Next step. Next step. Next step. Third step. Yes. 142. Just write 142, then 10 dot. Next. Yes. Yes. Last one. Earlier one. Now, this is what the provision which was added in late 2019 and then again amended in late 2020. you can refer 142(1)(a). It says the proper officer may. Earlier it was shall. I'll just deal with this difference of may and shall. Before service of the notice to the person chargeable with tax, interest and penalty under subsection 1 of section 73 or subsection 1 of section 74 as the case may be, communicate the details of any tax interest and penalty as ascertained by the said officer in part A of form GST DRC 01A. Precisely this provision says, rule 142(1)(a), it's a kind of pre-consultation which used to be there in the service tax law, service tax era, that the moment you will send the pre-show cause notice, before that you will have to send a computation or the amount or a summary of the amount which you have ascertained with regard to tax, interest and penalty. You will have to send to the dealer, to the taxpayer. Now what happened? Many a time you will see, or rather I would say most of the time, only in 5% cases I have seen that the DRC 01A is being served. In other cases, DRC 01A has not been served. Directly you will receive DRC 01. I hope you will agree with me. Now, if you are not following this particular aspect, that the department is not following the procedure which is prescribed in the law, whole of the exercise is null and void, in my humble opinion. So please make sure the moment you receive, you please check whether DRC 01A has been served or not. Now the question may arise. I'm sure so many people must be having in your mind that, okay, now it is May, and May means what we normally understood or what we used to read it. May means may or may not. That is discretionary. Correct. May is discretionary, no doubt about it. But that discretion has to be exercised. No, I'm not talking about this 142(1). We are on 142(1)(a). No, it was already there, madam. Just below 1A. No. You please hold it here. Yes, 1A. So show cause notice has to be there. It is there at shall. Earlier, when this 1A was introduced, shall was mentioned here. And with the amendment in 2020, the same has been changed with the term may. Now see, whenever there any discretion is given to a particular officer or an authority, that discretion has to be judicially exercised. If the lawmakers had the intention, no, it is not required. If someone, or rather, let me tell you very frankly, the officers are, after this amendment, officers are reading this particular provision like, okay, if we are not sending it, no, not a problem. Not a problem at all, because it's May. Had the legislature or the lawmakers wanted that it is not required, then this provision was not required here at all. This provision was not supposed to be there. As of now, this provision is there with a discretionary verb may. That means discretion has to be exercised judiciously. Meaning thereby, either this 1A has to be issued, and if not issued, reason for not doing so has to be there on record. That why we are treating this case as a fit case, not to give up pre-communication. Can there be any reason in the GST law that officer doesn't want to give a 1A? Is it a kind of provision when you will give a 1A and that person will fly away, and by giving a 1 he will not fly away? No, it's not. So discretion means judiciously exercising discretion. It doesn't mean arbitrariness. That okay, we are not giving 1A. No, it cannot be. So in my humble opinion, even after this amendment, either GST or 1A is required, And if it is not there, then a noting or reasons for not issuing 1A has to be there on file. Now, what one should do to take benefit of it? The moment you receive a SCN without DRC 01A, my humble suggestion to all my friends here is, please take a copy of note sheet, record sheet, processing sheet, whatever sheet you call it. Because in all government department, what happens whenever there is a proceedings are going on, you must be well aware with it. I am not supposed to deal in gratitude, just to touch upon for the younger friends who must have joined the profession now. In each and every department, whenever there is a case is going on, there has to be a note sheet whereby officers are supposed to record all the proceedings, what has been done in that case. Please ask for a certified copy of it. Please ask for a certified copy of it. Now, there may be a question in mind of couple of participants. Sir, we have asked for the certified copy, but department has not given. Or they have said, okay, we are not supposed to give us, the department is not supposed to give us. This kind of response is being given. Please mind, once the show cause notice is issued, the department, someone is, Akash is saying, yes, sir, they are not right. Let me complete. Now there is a question whether certified copy can be asked before passing. Yes, absolutely, 100%. There is no doubt about it. Before passing of the order, but please mind what I am saying is after issuing of the show cause notice. Indeed, it is responsibility of the officer to give you all relying upon documents and the relevant documents of the file to you. The moment show cause notice is issued, please mind the moment show cause notice is issued, inquiry is over. Now you can have each and everything from the file. It has to be transparent. It has to be transparent. Now let me tell you a classic judgment of the Supreme Court, whereby you can take it with you and show to the officers that you are mandatorily required, not only required to give us the copy of the documents, rather you are supposed to give it us on your expenses. That means on the expenses of the department, not on the expenses of the assessee. Sangi Textile Processors, landmark judgment from the Supreme Court. If I'm not wrong, 1993 judgment, 1993 judgment is, this one is maybe reported in 1993, maybe a couple of years back judgment, 65 ELT, page number I cannot recollect. Please go with this judgment. Very, very small judgment, a one-pager judgment. What happened in that case? The department has relied upon plethora of documents. And what happened, you know, whenever there is a show cause notice, department gives a RUDs, relying upon document to you. Department has not given the relying upon. Assessee made the application. I need these kind of documents and information on the basis of which you have made the case. They said, okay, not possible because there is a huge document. So the assessee said, okay, allow me to visit that at least all the documents. I will pick and choose what are relevant for me. Department, no, we will not allow you. The way a couple of my friends are writing, they are not giving, or can we ask before the passing of the order? So they have not allowed. So matter reached up till Supreme Court in the case of Sangi Textile Processors. And Supreme Court in a very crystal clear terms, in only a single page judgment, one page judgment is there. A crystal clear term said, no, you are supposed to provide. You have to provide the documents, and if maybe it is not practicable, you have to allow the visit, and whatsoever being identified documents, you have to provide on the cost of the government. Not like, okay, you are supposed to, you are going it to the, okay, you pay so much of the fees and etc. Nothing doing. If you want to proceed case further, you provide the relevant document. So I'm coming back to my humble advice to my friends, whenever you are receiving any show cause notice, without DRC01, without DRC01A, you have received DRC01. Please ask for a copy of note sheet. And the note sheet will, I'm telling you with my experience, the note sheet which you are going to get, it won't be having any recording about why the DRC 01A has not been issued. And this is going to be your, I must say, sole reason of winning of your case. Sole reason on the basis of which you will win the case. That ultimately on a higher forums, I cannot commit about the first appellate authority because I believe that without, maybe I don't want to disobey them, but whatever. I believe first appellate authorities are good for nothing. When you go to the higher forums, only and only on the basis of this, that a procedure was prescribed in the law and you have not followed the procedure, this is the concrete proof of it. The note sheet processing is what, sir, note sheet is there, which every proceedings has to be there. So this is what one aspect. Let me come back to SCN. The moment you receive the SCN, see, I have already passed more than 1 hour, and now I want to take up issues just like I have taken this one issue. Just wanted to check with you all guys, because I don't want to cover these provisions, 73 says this, 74, 107 appellate provision. I want to focus on the procedures which will be directly relevant to you. Is it okay? Should I go by that way, or you want me to take the legal provisions? Okay. Thank you. Okay, now there is a question that can note sheet be prepared by AO backdated? Normally, no. Normally, no. Okay, now let me come to back. You have received a show cause notice, and you noticed I have given 4 or 5 examples, 4 type of jurisdictional issues. Maybe one issue with regard to this pre-show cause. There are a couple of other issues which depends on facts of the cases. Now let us assume you have identified it. So what you are supposed to do? My recommendation would be, please raise a preliminary objection. Please raise a preliminary objection. That's very important. Why so? See, there is a general perception in the legal forums that you have received a notice and you had some kind of objection with it. And you think that the notice was not correct in one way or another reason. The officer is not correct, or the officer was not competent to issue these notices. Then you should intimate this aspect at the first instance to the officer, to the concerned person, to the authority who has issued the notice. If you have not done so, in that case, it is treated as you have submitted to the jurisdiction. You have submitted to the authority. Meaning thereby, in future, you will not be having shelter of these things. The issues which I am telling you, sole basis on the basis of, irrespective of the merit, you can win the case. Precisely speaking, this is what my way, I go by that way. You can win the cases on that basis. Maybe there are so many other things which I can tell you the moment there are some questions or issues are there. But if you are not raising this objection and you have responded to it, let me give you another example, 6th example. 5, I have given you 6th type of example. Let us say you have received a ASMT 10 notice. And I'm sure many of you must have received for the transition credit ASMT 10. First question comes to my mind. The moment I saw ASMD, I received in one of my client's case. Let me give you a whole practical example to you. What happened in real case? It was a matter of a builder, and in early 2018, GST was levied on 1st July 2017. A Tran one was supposed to be filed till 27th December 2017. We all know that. And there was a dispute, I would say. I'm not saying that one way or another, but there is a multiple interpretations are there whether builders will be eligible to take credit of the structure which is standing there, but not sold till now. I'm just appraising you facts of the case. Now, what happened? We received a notice, inquiry notice from the department in our case that you provide so and so details of, because our client has taken the credit, transitional credit of that structure. The department has asked us to provide whole of the details why your credit is this much high as compared to industry standards, etc., etc. We have simply responded to them. We have simply raised the preliminary objections due to one reason or another, that you don't have any jurisdiction to ask us this question. So kindly let us know why you have jurisdiction on us. We have given the reason that you don't have jurisdiction and you can't ask us this question in these kind of inquiry letters. Now, what happened after that? Department has issued ASMT 10 to the assessee in 2018 itself. In early 2018, maybe May, June 2018, we received a scrutiny notice in 2018 for that builder. What one should do with that? My first point is, please go and check. Can ASMT 10 be issued for a transitional credit? ASMT 10 is a notice when scrutiny has happened under section 61. Please open section 61, madam, if you are there. I'm sorry, actually, I'm not having any book or something with me. Due to some personal reason, I'm speaking from my home. Section 61. Whenever I'm saying section, that means act. 61 dot लगा दो मैडम, उसके आगे जल्दी आ जाएगा. Yes. The proper officer may scrutinize the return and related particulars furnished by the registered person to verify the correctness of the return and inform him of the discrepancy notice. Please mind that section. Please read the section very, very carefully. First, there has to be scrutiny of the return and other documents. And if there is a doubt that there is a lacking of correctness, there is something wrong in return, there is some discrepancy in the return, not in any other particular, then only the information can be given to the officer in the manner prescribed, and rule says this, the prescribed manner is ASMT 10. So first of all, can you ask me anything in relation to transitional credit and return? Can Tran 1 is a return? Answer is no, it is not a return. So what we did is, first notice we responded, you don't have the jurisdiction. Second notice we received in the form of ASMT 10. We again responded that number one, you don't have any jurisdiction. We have already told you. Second, you have issued the notice under section 61, which is not supposed to be issued for the transitional credit inquiry. I can tell you, it was the issue of 2018, which I am telling you, and we are sitting in 2022. We haven't received any further notice in that case. I don't know whether we'll in future also there are one more year is there. It can be issued till 2024. Whether it will be there or not, I don't know. But precisely speaking, department could not find the way to ask. So this is how one should deal it. That means the moment you are finding some kind of fatal errors in the notice itself, then in my humble submissions, one should immediately raise, at the first available opportunity, raise the preliminary objections. There may be some issues. The moment you are raising preliminary objections, officers take it on their ego. Ego gets hurt. This is okay, you are challenging our authority. But when you are into legal practice, you should not bother about. You are not into compliances or you are not into consultation. Now, when you are into litigation era, then at least one should not bother about. You go by legal way or maybe diplomatic way you can choose that okay sir, ye to on paper it is like that only, but okay, whatever way you go ahead, but I choose very strict. Anyway, now there can be a discussion and debate that is it mandatory that whenever you are raising a preliminary objection, the officers are supposed to dispose them of? There may be a question in your mind. Is there any provision in the GST law with regard to preliminary objections? There is no. There is no specific provision in the GST law regarding raising of any kind of objections or preliminary objections. This is what all your text jurisprudence which tells you. You may refer the judgment of Honorable Supreme Court in case of GK and Drive families. It's a 2003 judgment. And after this judgment, in 2010, the Gujarat High Court in the case of MGM Exports followed it and explained the concept in a very, very nice manner. And by these two judgments, you can conclude, or you can frame a view that whenever any preliminary objections are issued to any fatal errors, it is necessary for the officer to dispose them of first before proceeding to the case further on the merits. So whenever you receive the show cause notice, you have gone through with it, you find any kind of fatal errors, my suggestion, you please always raise a preliminary objections with a prayer, that specific prayer, that to the authority that please dispose of the preliminary objections first before proceeding to the merits of the case. You may have different kind of responses from the different authorities, like maybe someone may say no, we are not supposed to dispose of. Someone may say that okay, we will dispose of with the main order. Someone may ignore it, may issue the second show cause notice, something like this. Here again, my suggestion, you raise the preliminary objections once, then don't raise it again and again. Once is enough. Don't irritate officers. You have already saved your case. But one thing has to be ensured. The moment, let us see, you have raised the preliminary objections, you have the officer has said we are not supposed to give, or I'm not giving, or you have received the second show cause, or you have received the I will dispose it with the main order, something, whatever you receive. Now you have two options with you, and decision has to be based on the case to case. Number one, you can go directly to the High Court in writ petition here, that preliminary objections are not disposed of. Number one, depending upon case to case. But if you assuming that you are not going to High Court, now you are supposed to reply. Now you are going to reply on merits. But please mind, always make sure that you make a disclaimer, a two-liner disclaimer, that we have raised the preliminary objection, white letter dated so and so, but the same has not been disposed of, or whatever they have already said, and reserving all our rights to cooperate the department. We are submitting reply on merits like this. So by this manner, you can provide the detail. So you should proceed with the replying to the show cause notice. This is what a correct way of handling. Just what is written, he can issue ASMT 10 to verify the correctness as mentioned. Yes, correct. So correctness of what? I'm sure this Yash Aswanji is asking a question with regard to my example of transitional credit. Correct, Yash? So my point was, ASMT 10 was issued to verify what? Verify correct. He can ask the correctness of return, and Tran 1 is not a return. So you cannot ask for it in ASMT 10. I hope you got it. Now let me proceed with some other issues. See, it's a very common problem, I would say. Nowadays, whosoever are filing appeals, you all are well aware what are the provisions in the GST law for the appeals. Quickly, within 1 minute, I'll try to summarize the provisions as far as pre-deposit are concerned. If you are aggrieved by the order of the adjudicating authority, you can file an appeal before the first appellate authority under section 107. Section 107 says that before filing of the appeal, you are supposed to deposit whole of the agreed amount and 10% of the disputed tax demand. That means assuming there is a 100 rupee tax, 50 rupee interest, 100 rupee penalty, let's say 250 amount demand is there, then you are agitating whole of the demand. Then 10% of the tax amount, that means 10% of 100 is to be deposited. For a demand of 250, you are supposed to deposit 10 rupees as a pre-deposit before filing of the appeal. This is what requirement of section 107 subsection 6. And section 107 subsection 7 says if you deposited that amount, then your demand will get stayed. Yani rest of the demand, that means 240 rupees cannot be recovered by the departmental authorities. You will just recollect what we have discussed earlier, that 3 months are there with the taxpayer to file the appeal or to deposit. Let us assume that the taxpayer chosen to go for appeal. So he is supposed to deposit 10 rupees. So rest of the 240 rupees in our example cannot be recovered by the department till disposal of the appeal. This is what first appellate authority issue. Now, if the first appellate authority's order is not in your favor, then you have every right to go to second appeal, which is GST 80, GST Tribunal. We all are aware that GST Appellate Tribunal has not been constituted. Keeping that in mind, just let's have a appraisal of the legal provision. Section 112 is on similar line as that of section 107 subsection 6. So 1128 says you will have, if you want to file an appeal before the GST Appellate Tribunal, then you are supposed to pay whole of the undisputed amount, that means admitted amount, and 20% of the disputed amount. This amount, 20%, is in addition to the 10% which you have already deposited before first appellate authority. That means total 30%. That means if you lost the case at first appellate forum and you are going to second appellate authority, in that case, total amount of pre-deposit would be 30 rupees for the case of 250 rupees in our example. So this is what the legal provision. And similarly, section 1112 subsection 9 says that if you have deposited this much of the pre-deposit, in that case, no recovery shall be made till the disposal of the appeal by the GST Tribunal. Meaning thereby, now there may be a question in mind of the participant that there is no GST Tribunal. Then let us say if we lost at the first appellate forum and will not be able to file the appeal before the second appellate forum. Whether we have not filed the appeal, despite this fact, whether this demand will be stayed or not. Please mind and go through with the legal provisions very, very carefully. Section 112 subsection 9, which tells about the stay on recovery of the demand, is not dependent upon whether the appeal has been filed or not. Appeal to the tribunal has been filed or not. It is exclusively dependent upon whether the pre-deposit amount has been paid or not. Meaning thereby, let us say first appellate has decided the case against you, and since there is no GST Appellate Tribunal, you have not filed the appeal, but you have made a pre-deposit of 20% of the tax amount, in addition to what 10% you have already deposited. In that case, recovery will be stayed as per provisions of section 112 subsection 9. Please mind it. So stay on recovery Under section 112 subsection 9 is not dependent upon filing of the appeal. And you must be aware that filing of the appeal before the appellate tribunal through a removal of difficulty order number 9/2019, if I'm not wrong, dated 3rd December 2019. The government has already extended the time period for filing of the appeal, which will go with 90 days plus from the date of constitution of the tribunal, date on which the president will step into the tribunal. So as of now, time is there. Now, with regard to this pre-deposit, couple of issues are there. Some messages are there. Just a minute. Can the department recover credit availed in internment? If yes, under which section? This is not with regard to us. Recovery is always in 79. There are some disputes, legal dispute. I don't want to evade it. You may refer rule 121(1) as well. Mr. Rajesh Agrawalji. Then there is another question: how to go ahead with second appeal in absence of tribunal? I think I have already touched upon. You cannot file the tribunal. You cannot file appeal before the tribunal. But what you can do to protect your client: deposit 20% of the tax amount and inform the assessing authority that we have deposited the amount of pre-deposit as per section 118 subsection 8, 112 subsection 8, and as per section 112 subsection 9, the rest of the demand has got stayed. Next is rule 112 says additional evidence cannot be produced. Authority is saying since reply is not given, appeal cannot be accepted. And this is, I think, very, very factor specific. It's not about additional evidences. We have not talked about any kind of evidence which we are saying. At least I have not discussed yet anything about it. This is all about, we have raised the preliminary objections. Preliminary objections has to be disposed of by the department. Then we will file the reply to the notice. Anyways, so let me proceed further. I was on pre-deposit. Now a very big question is there: whether the pre-deposit amount for filing of the appeal, can it be paid by utilization of input tax credit? That is what the question I am putting it before all the participants. Let me see what answer comes. I'm asking a question to all participants. Can I make a pre-deposit for filing of the appeal by utilization of input tax credit? Yes, yes, yes. No, yes. Most of the answers are yes as of now. No, no. A couple of no's are there now. Yes. Okay. Anyways. See. Okay. Thank you very much for your responses. So many responses are there. By and large, I would say 60% people are saying yes, and 30-40% are saying no. No bar is there. Okay, fine. Now let's go through with the statutory provisions first. That's very interesting provisions are there. Section 49 is there, which talks about payment of taxes. That how the tax is to be paid. Section 49 subsection 3 is about how the ECL is to be used. Yes, someone has placed a very relevant judgment. Yeah, 49. Thank you, madam. See, 49.3. 49.3 is all about that cash ledger can be used for any kind of demand, tax, interest, penalty, etc., etc. We will discuss. I think Rajesh ji has put up this judgment. We will discuss that. And now read 4. So utilization of electronic credit ledger is described in subsection 4. It says the amount available in electronic credit ledger may be used for making any payment towards output tax under this act or under any integrated goods and service tax in such manner and subject to such condition and within such time as may be prescribed. So a very prima facie and quick reading tells us that cash ledger can be used for payment of tax, interest and penalty, whereas credit ledger can be used for payment of taxes only. This is what one quick difference between 49.3 and 49.4. Very quick difference if we talk about. And if we talk about what used to happen in the pre-GST regime, yes, we used to pay pre-deposit amount by utilization of input tax credit or a Senate credit. Senate credit, there was never the problem with this regard. But depending upon state to state, the authorities has issued, made the cases whereby the pre-deposit amount, they have rejected that. They said, okay, no, it has to be deposited in cash. Anyways, since the provisions of the GST law as far as demand and collection is concerned and appeals are concerned are in line with the central laws, we can say that each and every person was having a same opinion that all these stuff are linked with the same analogy of excise should prevail. Right. Now, what happened? Now we have a judgment from, which is there in the chat box, Jyoti Construction. This came from the Odisha High Court in October 2021. Very good. But you can keep sharing the CGST Act. So that in that judgment, Honorable Odisha High Court has said, no, pre-deposit has to be paid by way of cash only. ITC cannot be utilized. Now let us try to understand what the reason was there in the judgment of the Honorable Odisha High Court. Let us read this 49 subsection 4 once again. The amount available in electronic credit ledger may be used for making any payment towards output tax. It doesn't say tax. It doesn't say tax. It says output tax. Whereas if you refer section 49 subsection 3, it uses the word tax. 49(4) uses the word output tax. That's the difference between these two. And term output tax has been defined. Output tax has been defined in section 2 subsection 82. Madam, you may go at definition clause 2 subsection 82. Output tax is being defined to mean tax chargeable on taxable supplies made by the taxpayer. Now the question is 2 subsection 82. Madam, you may come on top. You may come on top. Starting pages. Precisely 282 describes output tax to mean that tax chargeable under the law on taxable supplies made by the taxpayer, and it doesn't include RCM. Yes, 82, just a minute. Yeah, 93. Yes, just a minute. Yes. Output tax in relation to taxable person means the tax chargeable under this Act on taxable supplies of goods or services or both made by him or by his agent, but excludes payment by him on reverse charge basis. Now, please try to decode this 282. It says tax chargeable under this Act. Now, when the taxpayer is, now the claim of the revenue side is, then when the taxpayer is filing an appeal, there can be, broadly, there can be 2 types of demands. One with regard to less payment of the taxes, that means output tax has not been paid. One is a reversal of input tax credit. So either way, it cannot be said to be a tax chargeable under this Act from the appellant point of view. This is what a claim of the revenue side. That if it is a ITC reversal case, then ITC reversal cannot be said to be tax chargeable. Similarly, tax chargeable, since the appellant is not admitting the liability, he is not agreeing to the fact that this much of the amount is chargeable to tax. So how the revenue is reading this particular clause is 49.3 read with 282 is that since it doesn't fall, the amount of pre-deposit which you are paying doesn't fall within the definition of output tax, then you cannot use the electronic credit ledger, and hence you will have to utilize cash ledger balance only. That means cash amount has to be paid in cash. Though there can be a different interpretation of it, but let me go through with let me go on a very important another provision, section 41, which is actually the key driver of this aspect. Section 41, madam Aishwarya ji, you just control F41 dot. No problem. You may bring that. So 41 specifically says that the provisionally taken credit. Okay. The claim 41 is claim of credit and on provisional basis and acceptance thereof. Fine. So this section has been utilized by the Odisha High Court. They said the credit claim is provisional until unless it is accepted. Until unless that matching mismatching happens, this is a provisional credit as per section 41 subsection 1. Fine. And 41.2, please read section 41.2 from our point of view. It says the credit referred to in subsection 1 shall be utilized only for the payment of self-assessed output tax. Now, more than output tax, there is a word self-assessed in section 41 subsection 2. So now with this, what is self-assessed? Self-assessed, we know section 59 is all about self-assessed. Self-assessed means as per assessment of the taxpayer and what has been declared in its return. Now let us assume there is a case 100 rupee on which 100 rupees is the turnover tax. Taxpayer is paid the tax at the rate of 18%. Department wants to tax it at the rate of 28%. Accordingly, show cause notice has been issued, order has been passed. Now the question is, for this 10 rupees demand, can we utilize the ITC? Fine, for filing of the appeal, for pre-deposit of the amount. Now 41.2 says your self-assessed output tax was 18 rupees. So this is what the point where we get stuck. And Jyoti Construction, on the basis of section 41.2, has concluded that no ECL cannot be used for making pre-deposit amount. Credit ledger cannot be used. You will have to make payment in cash for the pre-deposit. Now let's take a pause here. This is what I have explained, what are the prima facie legal provisions and what has been expressed by the Honorable Odisha High Court. Now let me put my views in a very, very brief, because I'll put up some different aspects also. Very brief, I'll put up my particular point on this. First of all, if we restrict ourselves to the 49.4 and 282, in my humble opinion, it talks about output tax, and ultimately even reversal of the ITC is also accumulated in terms of, is also culminated in payment of taxes itself. So both are output tax, number one. And you agree with me, DRC, the system also permits, GSTN permits it, leave that system, but otherwise also, just for your information, it permits it. That cannot be the law, but it permits it always. Now I read section 41, yes, it gives a reading, but in my humble opinion, with all due regards to the judgment of Honorable High Court, the Honorable Odisha High Court has failed in appreciating a scheme of the law, and they have read the section 41 in isolation. They have read the section 41 in isolation, whereby it is a complete scheme which was there in section 41, 42, and 43. What is that? Claim of input tax credit will be provisional till the time it is matched, and matching and mismatching is there in section 42 and 43. And 42, 43 match mismatch has never happened and rather dispensed with now. So the moment it is dispensed with, we cannot say 41 will be in 41 in isolation will be operative. If so, that means even till the time whatever credit has been taken under the GST law, that will be provisional. That cannot be the scenario. So in my humble opinion, the scheme of law should be read in as a whole, not in only isolation. 41 can be read. 41, 42, 43 all put together can be read. So the moment once credit is finalized, which was supposed to be finalized within 2 months' time, if the system was performing correctly, So I have, the moment I have availed the credit, now it is a final credit. Anyways, this can be a litigative factor. And we all are aware, the moment some pronouncements are there from any of the high courts on interpretation of the provisions of the any legislation, any central legislation, the same is bound to be followed by whole of the country, except there are contrary judgment. If there is no contrary judgment, then that even high court judgment has to be followed. So there is no contrary judgment from the Honorable Odisha against the Odisha High Court judgment. So it has to be followed in its what has been said. But now I am giving you one more interesting insight. Now please refer Finance Act 2022, which has completely replaced Section 41. They have substituted Section 41. You must be well aware about it. Though notification is yet to come, but the Finance Act has already been approved. So the moment the same is notified, the ill effect of Section 41 will also go. Please note 41 subsection 2, which is there, which is a part of Section 41 itself, has been completely substituted with the new Section 41, and new Section 41 is not having any kind of provision which is there in subsection 2 existing 41(2). So the ill effect of Section 41, which was discussed by the Honorable Odisha High Court in Jyoti Construction, will also go. Fine. Now let me tell you another judgment which you may utilize if you are finding yourself in some kind of difficulty, that okay, you are stuck up with these kind of things, that okay, we are not having cash and we want to pay the pre-deposit amount by the credit only. Please refer judgment of Honorable Delhi High Court, which came in last of April. If I'm not wrong, 28th or 29th April is there, in case of Mr. Amit Gupta. Let me tell you what happened in that case. That's very interesting. See, there was a case made by the GST department, DGI specifically, and they have arrested this person. And the lower court, session courts, has granted the bail to the person arrested on the condition that he will pay this much of the amount. If I'm not wrong, 2 crore something was there, that he will deposit this much of the amount. Now what happened? In compliances of the bail condition, that fellow has deposited 1 crore something out of cash ledger and 1 crore something out of credit ledger. This is what he has done. Now what happened? Department approached to the court again for cancellation of the bail, that he has violated the condition of the bail which was granted to him. That the court have given have asked to deposit 2 crore something, and they have deposited only 1 crore something from cash, and that is the other is a just kind of accounting entry. This is what they explained to the court. And the session court has cancelled the bail. Session court has stated that we have asked to deposit 2 crore something and you have not deposited, so bail condition has violated, so your bail has got cancelled. This fellow reached before Honorable Delhi High Court, and they have expressly shown the provisions of the GST law, which I was explaining to you earlier, Section 49, subsection 4 mainly, and they explain that the payment of taxes under the GST law can be made through the input tax credit as well. Thereby, the Honorable Delhi High Court has specifically noted it and passed the order recently, which I'm telling you in the 28th or 29th of April order is there. 1 month has not elapsed now. They have specifically said taxes can be paid by way of electronic credit ledger as well, even though it was not a self-assessed tax. So you can utilize this particular judgment and go ahead within your appeal with payment of credit. Rajesh ji is kind enough, so providing me the inputs wherever I skip it. Thank you very much, Rajesh ji. It is 29th April 2022. Now, one or two interesting aspects are also there in regard to pre-deposit. I'm just asking a question to you guys. I'm just posing a case study or a question to you. Let us assume you have received a show cause notice or pre-show cause notice in DRC 01A or 1, whatever it is, RD notice. I want answers of maximum persons on this question. You have received a DRC 01A or 1, whatever. And after that, you have deposited some of the amount. Let us say department wanted you to deposit 1 crore rupee. You said, okay, you understand that, okay, you are negotiating with the department that, okay, we understand that we have paid correct taxes and etc. etc. But still one of the point, like we are okay, we can go ahead with payment, and let's say 20 lakh rupees is there, with which you want to compromise with the department. Okay, there is an interpretation issue. Even then we are okay to deposit this amount. So you deposit that amount, let's say 20 lakh rupees under protest. But department doesn't agree with it, and department has adjudicated the order and passed demand of 1 crore rupee plus taxes plus interest plus penalty. Now my question is, and department in its order mentioned that 20 lakh rupee has already been deposited. Now my question is whether this 20 lakh rupees which you have already deposited, which has already been covered by the order of assessment as well. Can you use this? Now the question, question is whether you are supposed to treat taxes as 100 minus 20, 80 and 10% of 80 lakh, that means 8 lakh you are supposed to deposit. Or you can say, okay, 100 lakh rupees is the taxes, I have already deposited 20, so I am not supposed to deposit anything. More than 10% I have already deposited before filing of the appeal. This is what my question. You are supposed to pay 8 lakh or you are not supposed to pay anything? This is what my question. I'm waiting for the responses. 8 lakhs need to be deposited, nothing to be deposited. Already deposited, section say disputed amount. Yes, whole amount. I have, see, when I have 20 lakh I have deposited, that means, and under protest mean it is under dispute only. I'll reply to give notice received in I'll 10 minutes I'll keep specifically for question. Let me quickly wrap up some of things which are there in my mind. I'm very raw today. Okay. So see, in my humble opinion, you can very well utilize that 20 lakh rupees as a pre-deposit. You can very well utilize. There is, I don't have any doubts in my mind. You may refer judgment of Honorable Supreme Court in case of VVF India Limited versus State of Maharashtra in case of VAT law, Maharashtra VAT law. So that was, in that case, it was clearly held and the provisions are pari materia. Now coming to a very different situation. Now what happened? Another situation with regard to pre-deposit itself. Now what happened? At a one, your client, we know that the economy is not in a very good condition. Businesses are not flourishing nowadays. Your client is having a cash crunch. And we know that there are refunds which are being stuck up of the assessees. Now your client is the one in whose case in one of the year you have filed the refund and refund is ascertained, but you have not received the amount. On the other hand, there is a demand for which you have to file the appeal, and you have not a cash. You don't have any credit also. How to file the appeal? Can you take a plea? Can you take a plea that refund which is already determined or ascertained can be used by the department as a pre-deposit? This is a question. Quickly, I want a quick answers on it. Yeah, there is all answers are yes. One is no. See, please mind, there is no legal provision to it. There is no legal provision to it that it can be done so. But there are so many judgments whereby honorable courts allowed these things, that at one hand you are supposed to receive, at one hand you are supposed to deposit. So it should be allowed. One of the lovely judgment is from Honorable Gujarat High Court in case of Vinayak Trade Exim, if I'm not wrong, 2020 judgment is there, recent judgment is there. So you can refer that and apply in your cases. I'll just take another 5 to 10, though issues are like we can discuss for any point of time. Yes, I told you for discussing one or two aspects of services of the notice. Okay, let me take that in reasonable detail. I'll not be very brief. I'll not be very detailed, but we'll touch, because I'm sure each and every it will be useful for each and every one of you. Nowadays, what happened? Notices and orders, including summons, are being received over email. Aishwarya ji, a humble request, please open CGST Act. So all the notices are being received on emails, common portal like this. Now let's have a very practical situation which I faced recently with one of my clients. There was an employee whose email ID, who was an accountant and whose email ID was registered with them, and that employee got expired. Department sent the notices to that email, and for obvious reason that was not accessible or that was not readable by the management. Now what to do? Or what to do is the second thing. I think when there is these kind of facts, then that means some death is there, casualty is there, then everyone will treat it as a bona fide case. I'm taking up other cases as well. Not even death. Employee was transferred. Let us say employee was not transferred, employee was there, he has not opened the portal. Now the officer says, okay, we have already sent to you on this date. Is it my duty that I open my portal on a regular basis? Is it my duty that I open my email on a regular basis? Is there any kind of responsibilities being casted under the GST law on me? Now I am discussing a very limited aspect, because you know that filing of the appeal responses all goes by the date of service. What is the date of service of any notice, order, summon, whatever, or any kind of other communication as far as email and common portal are concerned? Because we are sure that the moment it is a physical notice, then we are well versed. The moment physical notices are there, we sign it, and always it is in our notice. So date of service, we know. What is the date of service or time of service in case of email or common portal? That's a very burning point, because all the timeline limitations under these all stretch. Even it is not about the even GST law. Even otherwise, you must agree with me, we are struggling with these type of things. We all are struggling with all these type of things. When should be a notice or order should be treated to be served? In case of email or common portal? I'm asking a question. Madam, please keep it there. Can you please open section 169? No, date of reading, open 167, date of reading, date hosted on portal. Date hosted on portal, okay. I think date of downloading and reply to mail. I think each and every person has spoken from his heart, his or her heart. So let's talk about statutory provision. But can you tell me, have you ever encountered this situation whereby you were being able to get department to agree on it? That no, it is not the date of email or it is not a date of uploading on the common portal. A single case when you get the department to the, or you may, I will show some legal provisions with regard to it, because ultimately we'll have to go by law. Please read this. Section 169. Section 169 talks about services of the notice in certain circumstances. It says any decision, order, summon, notice, or other communication under this act or rules made thereunder shall be served by any one of the following methods, namely these. Then there are 6 methods. Thoda sa upar le lijiye, madam. There are 6 methods, one by one. Clause A. A says by giving or tendering it to directly to the messenger, giving in person, including the courier. Second, by registered post. Second is registered post or a speed post. Third, by sending a communication to his email address. Please mind, clause C is email address. Sending a communication to email address. Fourth, making it available on the common portal. So C or D, which we are talking about. E, by publication in a newspaper. Clause F, if none of the modes aforesaid is practical, by affixing the same which we commonly known as a chaspa. I don't know if you have in Maharashtra, you have some different word. In North, we all say chaspa of the notices, whereby they affix the notice at the outside of the wall or premises or whatever it is. So section 169, whenever you are going to discuss it, department is going to throw this section on your mouth, that these are the 6 modes. 5 are the first primary modes. We can use any of the 5 modes. And if not practical, any of the mode, then we will go by affixation. Fine. I'm not agitating it. There are 6 modes of communication. No problem. But it doesn't say, section 169 subsection 1 doesn't say when it shall be treated to be served. Fine. Now you recollect the days of the physical notices. Then in each and every case, even on today, there is a dispatch number and all the notices and order are being entered in the dispatch register. And then it went to the post and then it is being served to the ultimate taxpayer. So one is date of dispatch and date of receipt. These are 2 different dates. Now let's read next clauses. Please go ahead on to. It says, subsection 2 says, every decision, order, summon, notice, or any communication shall be deemed to have been served on the date on which it is tendered or published, or a copy thereof is affixed in the manner provided in subsection 1. Please read it very, very carefully. Now, subsection 2 and subsection 3 is going to provide you about the service of the notice or order. What it says, it shall be deemed to have been served on the date on which it is tendered. The tendered word, please recollect, it is being used with the clause A. Section 169 subsection 1 clause A only. It is using the word by giving or tendering. So this tendered word is used for clause A. Come back to madam. Come back down, madam. Or published. Now what is published? Published in a newspaper. Clause E, 5th option. So one publication in a newspaper is the clause E. So now clause 2 is talking about every decision or order or summon or notice or any communication shall be deemed to have been served on the date on which it is tendered. That means physically giving. Published, that means they are talking about newspaper, or a copy thereof is affixed. Now this is talking about fixation, which is the last clause F. Fine. So out of 6, for 3 type of communication they have provided when it is be treated. What is the date of service? Clause 3. Let's read that. When such decision, order, summon, notice, or any communication is sent by registered post or a speed post, it shall be deemed to have been received by the addressee at the expiry of the period normally taken by such port in transit, unless the contrary is proved. So this clause 3 is telling you date of delivery in case of registered post, not otherwise. Registered post is clause B. So please mind, section 169 is over and they have not talked about date of services in case of communication through email and communication through common portal, when this will be treated as a date of service. What will be the date of service in these communications, email and common portal? I hope you guys will agree with me, at least agree with me till here, that there are 6 methods of communication provided by the law, out of which GST law provides for 4 aspects what will be the date of service. For rest of the aspect, for rest of the 2 things, GST law doesn't tell you what will be the date of service. I hope you will be agree with me, at least till now. So that means GST law is silent. What will be the date of service in case of email or when the notices or orders are being posted on common portal? Fine. Let us move a step ahead. We are having a law known as Information Technology Act 2000. Information Technology Act 2000 in our country. Please mind, Information Technology Act 2020 is binding on all the other laws that I'm forgetting the section 81 or 83 is there in that particular law, which is having a non-obstante clause to all other laws. It clearly says notwithstanding whatever written in any other law. Just like you can recollect the SEZ provisions. Similarly, the provisions are there of the Information Technology Act that it supersedes provisions of other law. That means even if GST law was having a provision for with regard to communication of emails, then also the IT Act will prevail, whereby we have seen that GST law is silent on it. Fine. Now let us refer to the relevant provision. There is a section 13 in the IT Act, Information Technology Act, which tells us 4 things. In case of any electronic communication, these both are electronic communication. Let it be on a portal, let it be on a through email. So section 13 of the Information Technology Act tells us that what will be the place of dispatch, what will be the date of dispatch of any email communication, what will be the place of receipt of communication, what will be the date of receipt of the communication. So I'm leaving place aspect from here because it is not relevant for us as of now. Dispatch of information is being treated as per the law when it is sent from out of his control. That means someone has drafted an email. No, it is not sent from his side. The moment he has pressed the button send, that means now it is out of his control that he can stop that email. In that case, that will be treated as date of dispatch of that email. What is the date of receipt of that email? It is the date, it is the time, not only date and time I'm talking about. It is the time when that particular electronic information enters into the computer resource of the recipient. When it enters into the computer resource of the recipient. What is a computer resource? It is also defined in the IT Act. Computer resource means all of your computer, hard disk, etc., etc. But it doesn't include web or a cloud. So someone has sent something to email, until unless I read that email, or until unless I download that email, until unless I go to the common portal, open that email, it will not enter into my computer resource. It is only and only on web. Please mind, if you are using a Outlook kind of thing whereby something is automatically get downloaded, please mind it, that will be a different scenario. So important aspect is when it enters into your computer resource. So in normal cases whereby we all see whenever we access email, it shows okay downloading something like this. So that means now it is entering into the computer resource. Or in case of common portal, always when you first access it. So that is the date and time when one can say it is being received. So many cases are there whereby we have get to know, okay, after 4 months, 5 months, 6 month time period. Now the order has been received, now the notice has been received, and we think that, okay, time is over. Please mind, time is not over. Time will start computation from the day when you first access it. This is what my some of the observation with regard to this. I just noted one more important aspect, but I think we are already past of the time, so I may leave that. Otherwise, this topic is like we can talk for any time, maybe 4 hours, 5 hours. We can talk on this. So many things are there which are useful, but I'm leaving it here and open for any kind of questions for next 5 minutes. I have another meeting after 10 minutes time. So I must thank you, the Pune branch for giving me this opportunity, and I apologize to all the participants, all the members, that I was highly unorganized today. No PPT, nothing, because of some personal reason. I am addressing it from my home, and whatever was coming in my mind, I was just editing. I hope some of the points will be useful for the members. Thank you. Thank you.
Sir, excellently covered. Excellently covered, sir. Excellently covered. Even though there was no PPT, it not feel like there was no reference, because you correctly touched act wherever necessary or rule.
Thank you. Any questions are there? I'm here for next 4 or 5 minutes.
So we've received a few questions.
Yes, please. Not there in the chat box.
In the question and answer session.
Q&A. Okay, I'll read it. I'll read it from there. Just a moment. Give me a moment. Okay. Mr. Manish Kumar says, sir, received notice in DRC 01. Okay, in email, but no reply given within time specific. How to proceed? Very fact specific. The question I need to, the facts I need to understand here is, as of now, whether the assessment that the order has been passed or not. If the order has been passed, it's altogether different kitty. If the order is not passed, go ahead and now respond. It is duty of the officer to consider your reply, even if the time has elapsed, hardly matters. Fine. If the order has been passed, then definitely I'll have to check some of the other aspects as well. This has happened. Now next is, sir, notice issued, which is, this is again Manish Kumarji. Sir, notice issued, which is technically incorrect and dropped. Okay. Okay. Can fresh notice be issued for the RA? That's very beautiful thing. Okay. Actually, I wanted to touch upon it. Okay, I'll just very quickly, I'll give you the other activity. See, when you try to get answer only and only from GST law, probably you'll not get answer to everything. You'll have to know about the other laws. See, if a notice is dropped only and only on the technical reason, exclusively technical reason, they have not touched the merit. In that case, yes, it can be reissued. Number one. Number two, let us assume they have touched the merit. Now what happened? Let us, now we know that we are having observed and adjudicated by so many agencies, state, center, and in both state and center, we are having regular wing, regular administrative wing, adjudication wing, audit wing, enforcement or anti-evasion wing, then DGGI. Total 7 agencies are there, which we are, each and every taxpayer is facing. So now what happened? Now one wing has touched upon a particular aspect, they dropped, another wing come and they also adjudicate. To some extent, there are shelter available in section 6 2B, but let us assume there is a state wing which have audited you. Now the assessment wing or enforcement wing wants to make a case on you. Please mind, let me tell you, let me refer one of the aspect is section 11 of the CPC, which is the principle of res judicata. That means if one aspect has already been touched or assessed, it cannot be retouched again, number one. Now, I'm going to tell you one more interesting concept, which is a constructive res judicata. I'm very, very quick on these aspects. If someone wants to take it, we can, those people can read from those aspects. Explanation 4 to section 11 of the CPC, which says if a point could have been raised or ought to have been raised, but not raised, is also covered by the res judicata. That means once our assessment is done, once our audit is done, and you have not escaped anything from your side, now it is finalized. You have not raised one point. Now you cannot raise the another point in a future proceeding that you come and say, okay, something has also escaped. No, you cannot do. Third aspect of these type of things are when a person has audited or done some assessment, it cannot be assessed by any other authority. Even in the different stream, like let us say state adjudication wing has done some adjudication, done some assessment of the determination of the tax liabilities assessment. This is what I told you in the session as well. Now let us say regular administrating wing has assessed it. Central authorities cannot come as per the section 6(2)(b) as well. But even the other state authorities can also not come. This is what my point. Please refer judgment of the Honorable Supreme Court in case of Canon India. If I'm not wrong, para 11 specifically says the assessment can be done by the same authority only. Reassessment cannot be done by any other authority. That means if the regular wing has done the assessment, he will do the again only. No other person will do. So that's very important for handling these kind of show cause notices and appellate mechanism, that no other person can do it. And res judicata is a very important principle, along with constructive res judicata, as I shared with you in section 11 and explanation 4 to section 11 of the CPC. That's important for all the chartered accountants to read that for handling litigation practices. Now coming to the next is, sir, please discuss in detail about how can we check our jurisdiction. When we search by GSTN number, there is one state, one center jurisdiction office, one which, see, this is not a perfect way to check that. Though when you check on GSTN, it says admin office, this one, other is this one. So admin office is the actually correct jurisdiction which you have. But the correct way to check is there is an order for it. For each and every assessee, there is an order specifically. What happened? You may note it down. Circular number 1/27 issued by the GST Council dated 20th/9/2017. They have issued the guidelines to all the state and central government to make the division of the taxpayer base. Pursuant to this circular, division of the taxpayer base was done by each and every state most of the time in November and December of 2017. So in each and every state, you will find a specific order signed by the top chief or the chief commissioner of the central taxes and chief commissioner of the state taxes. Joint order is there, dividing the taxpayer base. So you will have an order. You can get that order in RTI as well. That particular assessee is assigned to state or center. This is what the aspect you can. This is the correct way to get it. Or most of the orders are available on the website as well of the respective state departments. Next, refund on.
Hello.
So, can we skip that long questions, because I think I'm also.
So I think time is already over. If you want, we can just take one last question and close.
If taxpayer does not have cash or ITC for pre-deposit, what option is available? Oh, that's very. I'm sorry to say. It is a statutory option, and so many Supreme Court judgment has they analyzed it. Initially, in some of the cases, High Courts granted the admission of the appeal, but appeal is a statutory mechanism, and pre-deposit conditions are mandatory. You will have to abide by that. If you want to file an appeal, then you have to pay the pre-deposit either by way of ITC, as I discussed, or cash. But you can definitely try to explore if your order passed by the authority fits into any of the 4 limbs. Number 1, there is a breach of fundamental right. Number 2, opportunity of being heard are not given. Number 3, there is a issue of jurisdiction is involved. And please mind, when we talk about that principles of natural justice are not followed, it doesn't mean that just an opportunity is given. It means a proper, reasonable, all opportunity is given. And 4th issue is when you are challenging a virus of any law, rules, or notification. If you are fitting in, if your order which is passed against you is fitting into any of the 4 limbs, in that case, you can directly go to High Court. Whirlpool Corporation is a landmark judgment to it. You can follow that and directly go to High Court. No need to file the appeal. In that case, no pre-deposit is required. You will have to diligently work on that. I think with this, we can conclude. I must say thank you each and every participant. Thank you to the branch, and Mafi Chaunga for all the mismanagement which had happened under. Thank you.
Nice, sir. Thanks a lot from our side for on Sunday. You have given your valuable time to enlighten us on the very important topic from profession as such. We, Managing Committee of Pune branch and all participants, on behalf of all participants, I convey my heartily thanks to you, sir. Really, you have covered so many aspects in just 2 hours. I don't like to stop you because so many concepts you are clearing, including this pre-deposit, service of the notice, and so many. I don't think I should stop here because I know litigation there is reading is must, and we should read continuously to understand the concepts and the you can say ambiguity in the law, where interpretation issues. Uh, I definitely like to invite you at Pune, but being it is a virtual, we are felicitating virtually, sir. So sorry for that from our side, but definitely I like to invite you to Pune in shortly, sir.
Sure, my
बहुत
pleasure.
दिन हो गए सर आपसे मिले.
My pleasure. It would be my pleasure.
Yes, sir. Thank you, sir. Thanks a lot from all participant and Pune branch. Thanks, sir.
Thank you.